oyez, oyez. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning, everyone. Once again, welcome to the second day of the Tennessee Court of Criminal Appeals March docket. Let me once again reintroduce the panel for those of you who were not here yesterday. To my right is Judge Timothy Easter from the Middle Division, Franklin, Tennessee. To my left is Judge Jeffrey Usman from Jolton, Tennessee. And he has graciously agreed to be on loan with us from the Court of Appeals. Again, my name is Camille McMullen. I'm the presiding judge of the Tennessee Court of Criminal Appeals. I'm from Memphis, Tennessee, Western Division. The parties know you have 20 minutes per side. If the appellant wishes to reserve any rebuttal time, please let us know on the front end, and we'll keep track through the light system. Madam Clerk, do we have any preliminary matters?
No, Your Honor.
Let's call the first case.
State of Tennessee versus David Keith Gunn.
Thank you, Your Honors. My name is Ryan Duggar, and I'm here on behalf today of Mr. David Keith Gunn. I do wish to reserve 4 minutes for rebuttal.
Thank you. You may proceed.
Thank you. Our singular issue today is phrased, did the court err in denying Mr. Gunn's motion to suppress? I think a better way to phrase that in hindsight would be twofold, and that would be, should the police have left the property at 516 Pawnee Trail after taking Mr. Gunn into custody, or should they have gotten a search warrant to search the vehicle that was on the curtilage of the home?
Counsel, can I clarify one thing?
Yes,
Your
Your Honor.
argument is exclusively under the Fourth Amendment, right? Not Article 1, Section 7 of the Tennessee Constitution?
Your Honor,
You haven't advanced an argument under Article 1, Section 7 of the Tennessee Constitution, right?
I don't believe so, Your Honor. I believe it's mainly in keeping with the Fourth Amendment.
Okay, and you're not disputing that there was, if the officer was where the officer was lawfully entitled to be, you're not disputing that there was probable cause to search the vehicle itself. So the question is whether the officer could be there or not after the arrest, right?
That alongside, even if there was probable cause, we don't address that, or we're not arguing that there's not probable cause. If the officer saw what he saw, there's clearly probable cause to search the vehicle. It would simply be, should he have been there to get the probable cause, and if he got the probable cause, should he have then had to get a search warrant based on the curtilage issue?
Okay. Now, the United States Supreme Court in Scott v. United States noted, almost without exception, in evaluating alleged violations of the Fourth Amendment, the court has undertaken an objective assessment of an officer's action in light of the facts and circumstances then known to him or her. Given that, and the defendant in this case says, I'm homeless. When the officer asks, where do you live? How is the officer supposed to act under an understanding that he was actually living in the residence here with that response?
Your Honor, I believe the two main areas that the officer should rely on would be, one, his prior knowledge of Mr. Gunn, as he stated that he knew Mr. Gunn had resided at that residence prior. I believe he also stated that he knew the warrant that he was arresting Mr. Gunn on was related to some type of activity at 516 Pawnee Trail. The second main
robbery at that
what's
house?
That, Your Honor?
A robbery at that house?
I believe it was aggravated burglary.
So an aggravated burglary of a house, an outstanding warrant, but that's supposed to suggest to him that he actually resides there?
I believe, based on the officer's understanding, would be that he knew that Diamond Wilson and Mr. Gunn were in their relationship and had been staying there. I think that's further evidenced by Diamond Wilson's statements. The second half of that would be Ms. Diamond Wilson, when asked by Mr. Gunn during the traffic stop can you go get me a sweatshirt to warm up, she actually got the sweatshirt that was later used in a picture at trial to show Mr. David Gunn with a gun.
And that's sufficient to satisfy standing?
I believe so, Your Honor.
A shirt?
I believe that shows that he has a clear nexus to that home, that's where his belongings are.
Well, then anyone that has been a visitor to Miss Diamond and her mother, because I believe it was in fact her mother's home, has standing to challenge the search, correct? And that's not sufficient based on our case law.
Yes, Your Honor. I don't think a shirt alone would be sufficient, but I believe that paired with Officer McPherson's prior knowledge that Mr. Gunn had stayed at that property, I think those two paired together would show that he has standing at that property.
I don't want to cut off Judge Usman.
Oh, no.
I want to back up just a little bit because
Yes, Your Honor.
what was troubling to me about this particular case is you don't dispute that the officer had lawful grounds in a public place to stop the defendant before he drove into the driveway, correct?
That's correct, Your Honor.
So how can a defendant avail him or herself of Fourth Amendment protections when the stop and the grounds for the stop arose on public property?
Well, Your Honor, I could just highlight, this is a very uncommon case in that Mr. Gunn did appear to drive several miles to that residence.
5 miles.
However, he was not charged with evading, and
Does that make a difference whether he was charged with evading?
I don't think it's a prevailing issue, Your Honor. I think it's simply something to add that he's not charged with evading. It seems there was some ulterior motive in getting to the home. I would equate it that,
And was not
Yes, Your
that the central holding of the trial court here? The trial court was bothered by the fact that the defendant did not stop. The officer here engaged in full-on blue light sirens in a marked vehicle, and the defendant refused to stop for 5 miles and attempted to protect himself by driving onto the driveway of his girlfriend's home.
I believe that's correct, Your Honor.
So speak to me as to why he should be entitled to protection under the Fourth Amendment.
Well, Your Honor, I believe that you could make a parallel argument with someone who wishes to exercise their Fifth Amendment right against self-incrimination by not speaking to the police. If Mr. Gunn took affirmative steps to afford himself more protection, he shouldn't be disadvantaged for
Counsel,
that.
doesn't this fall within, and if officers are pursuing somebody, they can follow them into their home under the hot pursuit exception? And isn't this a variation on the hot pursuit exception, except didn't even have to go in the home, just went onto the driveway? So, I mean, aren't we in a well-worn exception to the warrant requirement? And if you can go into the home, I'm struggling to see how you can't, or would you dispute that this was a hot pursuit in this circumstance?
We would not dispute that in the least, Your Honor. We don't dispute the officer's ability to be there all the way until the arrest is effectuated. So we don't dispute that the officer could pull onto the property. We don't dispute the officer could get Mr. Gunn out of the vehicle. Had Mr. Gunn run into the home, we don't dispute that the officer could have chased him into the home. What we're arguing is twofold. One, that once the arrest was done and Mr. Gunn is in the back of the patrol car, that the officers should only remain on the property to do a protective sweep. The officer testified that he didn't do a protective sweep, that he walked around the car to see if there was anything he could take action on. So that's one argument, that he should not be still remaining on the property for some.
Well, let's talk about that. The officer said, smelled the odor of marijuana immediately emanating from the vehicle. That in and of itself allowed the officer to get into the vehicle, correct?
I believe so, Your Honor.
Plain view, observed the items of contraband on the seat, correct?
Yes, Your Honor.
That in and of itself enabled the officer to get into the vehicle.
Yes, Your Honor.
I'm confused as to what you're traveling on now, what ground you're traveling on to prohibit the officer from getting into that vehicle.
So, Your Honor, as I cited in State v. Beatty, that the state could do, or the officer could do a safety sweep. However, the officer did not testify that he did a safety sweep. He noticed the contraband after effecting the arrest. And our argument is that he should have gone off the property once the purpose of the stop was done, which was effecting the arrest for this arrest warrant. So at that point, the officer then did that sweep of the vehicle. So our first argument is that he should be off the property at that point once Mr. Gunn's taken into custody. The reason for stopping the vehicle is gone. Second would be, if Your Honors wish that, or believe that the officer is allowed to remain on the property, or this falls under a protective sweep under Beatty, that because the vehicle is on the curtilage of the home, now that is only if Your Honors give standing to Mr. Gunn to challenge that, but if the vehicle is on the curtilage and Mr. Gunn has standing, that the officer should then get a search warrant because of the Fourth Amendment protections of the curtilage of the
Counsel,
home.
how is any mistake here by the officer in terms of the residence not a reasonable mistake of fact? So if the officer, and you hear, where do you live? I'm homeless. And you're suggesting there's some facts here that maybe could have indicated that he had a previous connection with it, he was staying there. let's say the officer got it wrong but how is this not a reasonable mistake of fact by the officer in terms of assessing the circumstances that were confronting him here? And it seems like, to me, it seems like I wouldn't think he was living in that or staying in that residence. What makes that mistake an unreasonable mistake by the officer?
I don't think it would be an unreasonable mistake at all. We are relying simply on the fact that the officer knew that Mr. Gunn had a prior connection to the house and the
Doesn't
sweatshirt.
that preclude exclusion then of any evidence? I mean, if there's a reasonable mistake of fact made by the officer in conducting a search, and doesn't that take off the table exclusion of any evidence?
I'm unsure, Your Honor.
I think the U.S. Supreme Court in Hine deals with mistake of law, but going back to Garrison, took the view that a mistake of fact essentially takes error essentially outside the scope of the exclusionary rule. But I could be wrong on that point. But you're not asserting that if there was a mistake made here that it was an unreasonable mistake. You're saying it was a mistake, but you're not alleging that it's an unreasonable mistake.
No, Your Honor. I think as far as writing a brief, I perhaps couldn't foresee every argument the court could make and every argument I could make, so that's not addressed in my brief, and I'm not familiar with what Your Honor is citing.
Okay.
You can continue.
Thank you. As far as whether this property is curtilage, I believe the area of the vehicle in location to the home is clearly curtilage. The vehicle was parked, as noted in the photos, directly behind the home, very near the two back doors.
Let's talk about curtilage. And the facts of this case, because again, you were trial counsel? Were you
Yes,
trial counsel?
yes, sir.
You all did an excellent job in giving the court a picture from the body cam videos that the officers had. So we have an unusual situation where we can actually see where the officer stopped his vehicle, where the defendant was stopped. We have the photographs of that. We have aerial photographs of that. So we have all that information. We also have information that was developed at the hearing, which again, as a reviewing court, we really appreciate, that the home was a duplex. Is that accurate?
Yes, Your Honor.
And that the area that the officer drove into, following behind the defendant's vehicle, which was actually his girlfriend's vehicle, or his girlfriend's mother's vehicle, that drive was actually open to the other parties or the other residents in the duplex, correct?
Yes, Your Honor.
So there was no reasonable expectation of privacy in the area leading up to the, I don't know if you want to call it the garage area to the home, the girlfriend's home?
I would call it a parking area,
The
Your Honor.
parking
I don't believe
area.
there's any type of enclosed parking area there.
So
It's an open parking area.
This area, it was very, it was open. There was no, actions taken by the homeowner to protect that area from other individuals, people in the public, correct?
I would respectfully disagree, Your Honor. I
Okay.
believe where the vehicle was parked behind the home, an average person driving down Theta Pike or Pawnee Trail, as visible in the photos, would not be able to see what is inside the vehicle. And I believe that's further highlighted by the officer's testimony.
The standard is not necessarily could they see what's inside the vehicle. Was that area open to the public? Would an ordinary person feel like they could drive into the driveway?
And I believe one of the factors, Your Honor, would also be the steps taken by the resident to protect the area from observation by people passing by. I believe that's page 22 of the brief. So our position would be that on Pawnee Trail or on Theta Pike, someone passing by would not be able to see inside the vehicle. I think that's further evidenced by the officer's statements that they walked up to the vehicle on the property to do their view to see if there was anything they could take action on. And because the paraphernalia was not visible until you're right up on the vehicle, I believe that further supports his argument that he's not simply putting on the side of the road.
I'm going to try one more time. So let's look at it from this perspective. The resident on the other side of the girlfriend's home,
Yes, Your Honor.
they too used this area that the officer observed the contraband in the car, correct?
It would be speculation on my part. I'm not sure if anyone was living there, but I believe, for sake of argument, if someone was living in 516A, yes, Your Honor, I believe they would be able to see what was in the car.
Okay, a Girl Scout, if they were coming up to sell cookies to the resident at the mother's house and the resident in the duplex, they too would utilize this area, correct?
I would agree with that, Your Honor.
So that was the officer's point, correct, at the motion to suppress. He said this was the area that I believe that was open to the public. I wasn't going into the the covered parking area where that clearly led to the door, even though that too, there were no steps, there were no trespassing signs, there were no fences, there was nothing done to make this appear as if it was a private area. That's my point to you, counsel.
Yes, Your Honor, and I believe in keeping with the factors in regards to what is curtilage, I believe overall the proximity of where this vehicle was parked to the house strongly weighs in favor of Mr. Gunn. Him
And
not
the other
taking to the
factors-
steps.
Yeah, the other factors are whether the area is included in an enclosure surrounding the home.
Yes, Your Honor.
It was not. The nature of the uses to which the area is put, it's a driveway open to both the resident of the home and the duplex, the other side, the duplex. They both use that area, correct?
Yes, Your Honor.
And then the last one, the steps taken by the resident to protect the area from observation by people passing by. And that was my first question to you. What steps were taken to protect the area from observation by passersby?
And yes, Your Honor, and that's our position would be that passersby would mean people out in public, not already on the private property. So our position would be that he parked the vehicle in such a way that it's not visible from the public roadway, as well as its proximity to the home, and those two would weigh in favor of this being curtilage.
Counsel, can I ask a factual question here? Is there a mailbox on this property at the end of the driveway here? Or is the mailbox on the house and the duplex itself?
Well, Your Honor, I'm not sure how much I can get into. I actually used to live at this home.
Is there a photographic exhibit that would answer that question?
I don't think there's a photographic exhibit, but
Okay.
I lived in 516
The aerial
in high
shot
school.
doesn't seem to indicate.
There's one in front of the home
Okay.
that's in the front yard,
So
not
then
on the side.
There
it
may
was
be an
pulled in.
exhibit that reflects one way or the other.
I believe
but
you
there's-
could
okay.
possibly see it as a small dot in the aerial photo, but it wasn't ever addressed.
Okay.
Okay.
And
You may
I-
proceed, I'm
okay.
sorry.
No, that's.
And I want to draw a distinction in this case from the Collins case. Collins is not directly synonymous. Collins did a great job of highlighting just what is curtilage and then providing that Fourth Amendment protection. There is the really great quote in Collins that says, imagine the motorcycle was in the living room of the home. Would the officers then be required to get a search warrant?
Counsel,
And
didn't the officer, though, divert in Collins from the main route to the home, where instead of sort of walking the most natural way where the Girl Scouts may have gone to sell her cookies, the officer sort of diverted off to the side in the Collins case in a more unnatural path in terms of where the officer was walking, which is not really present in this case, right?
exactly, and that's the distinction. However, what's important about the Collins case is knowing that, drawing the line that curtilage is afforded more right than just being on the public roadway under the Carroll Doctrine. So I think that's the important distinction to draw from the
Collins.
case.
Okay, so Collins specifically distinguished between a stop or pursuit that occurs in public, okay, in a public place. If it begins in a public place, an individual cannot then seek refuge in a private place subsequently and seek protection under the Fourth Amendment. Collins specifically said that to distinguish the facts of Collins from evading or hot pursuit. So again, although you say Collins, gives the definition of curtilage or gives better refinement to curtilage, Collins carves out an exception specifically for situations like this, when an officer has lawful grounds to stop an individual in a public place, and that individual then seeks refuge in a private place. It's almost like if an officer is responding to a 911 call and sees an individual being beat down, that individual then runs away from the officer. The individual then can't run onto a driveway and claim Fourth Amendment protection when the officer actually apprehends the individual. That's just not, that's not permissible. So anyway, you can close. I've taken up the remaining.
May I
of your
respond?
time. Yes.
And that's what, we don't take any issue, again, with the officer being on the property. We wholeheartedly agree the officer has a valid reason to be on the property, and that's where we're trying to draw a distinction from Collins. We're not saying the officer could not be on the property. We're simply saying the reason for him being on the property evaporated once he took Mr. Gunn into custody. At that point, if he wished to take further action for the vehicle, he needed to get a search warrant. It's not simply that he's in hot pursuit of Mr. Gunn and runs into the property. We take no issue with that. It's simply that once Mr. Gunn was in custody, the hot pursuit or the need to search that without a warrant, it would
So
be
you're saying
evaporated.
he had to ignore the odor of marijuana and the things he observed in plain view?
No, Your Honor. We're saying that he then, at that point, once he noticed that, should have gotten a search warrant based on the proximity of the vehicle to the home being on the curtilage.
Thank you, counsel.
Thank you, Your Honors.
Mr. Douglas, it's good to see you.
Good to see you too. Good morning, Your Honors.
Good morning.
May it please the court, Davey Douglas on behalf of the state. This court should affirm the judgments of the trial court here because the trial court properly denied the motion to suppress. The defendant does not have standing to challenge the search, and the search itself was constitutional. And standing is that threshold issue that a defendant bears the burden of establishing. And
How does he not have standing? I'm thinking about Minnesota v. Olson here. How are you distinguishing this case from Minnesota v. Olson?
I think if we apply the sort of 7 factors that our Supreme Court has indicated we should consider in determining standing, the defendant really cannot satisfy any of those.
You wouldn't disagree, though, that Minnesota v. Olson establishes that an overnight social guest can have standing in a home, right?
I would not disagree with that, Your Honor. I would disagree that the defendant was, in fact, an overnight guest here.
He says he stays there 4 out of 7 nights. He keeps his stuff there, and that seems more extensive than what we saw in Olson.
He also testified, though, that he couldn't remember the last night that he stayed at the house. He testified he didn't remember if he had stayed there the night before the arrest, and then Diamond Wilson, his girlfriend, said that he didn't stay there the night before the arrest. So this, I think, makes him very different from an overnight guest.
I want to make sure I understand the facts in terms of his statements. Officer says, "Where do you live?" And he says, "I'm homeless." And also on cross-examination, he's asked if he's staying there recently, and he essentially says, if he understands he's not supposed to be there, and is he staying there recently, and he says, no, essentially, he hasn't been. So are those essentially the key facts in terms of distinguishing this from Olson then?
Yes, Your Honor, and another key fact is that the defendant knew he actually was not even supposed to be on the property because of the outstanding warrant for the aggravated burglary. He admitted to that as well.
Which affects the reasonableness of the officer's assessment in terms of whether they would think that he was living there or not. Yes, no, maybe?
It does, but I think it goes to his status as an overnight guest as well. It would cut against the assertion that he is an overnight guest.
Can't one be an illegal overnight guest? And I'm not supposed to be in the house, but I'm staying there.
One certainly could be an illegal overnight guest, but I don't think that the same protections of the Fourth Amendment would extend to an illegal overnight guest. In State versus Guy, this court sort of confronted a similar issue where the court held you lose standing if you, in fact, commit a crime against the occupants of the house where you're staying. And so I don't think the defendant here would be able to claim he's an overnight guest if he's not even allowed to be at the property. And we again have the testimony from Diamond Wilson that he wasn't staying there the night before the search. She couldn't remember the last time that he was there. And there's also no proof really of anything that he had in the house other than a single hoodie that would have established he kept his stuff there, that he was staying overnight.
Generally, even if he is an overnight guest, is this case covered by reasonable mistake of fact? And even if we're assuming for purpose of argument that he's an overnight guest, the officer got it wrong, was the mistake here reasonable by the officer?
Just taking those assumptions as true, yes, Your Honor.
I understand you're arguing against that that's not your position, but but assuming he is this case still, would it still fall within the reach of a reasonable mistake of fact?
I think it absolutely would here, especially based on the defendant's admission to Lieutenant McPherson at the scene that he was homeless. It's absolutely reasonable for the officer to take the defendant at his word, especially when it's a defendant who has fled for 5 miles after officers tried to initiate the stop. And I think that's another really important aspect of this case that shows why the defendant does not have standing. He didn't have a legitimate reason to be on the property. Judge McMullen, you alluded to this in your questions. Essentially, under the defendant's interpretation, somebody can flee from police who try to initiate a stop in a public area, get to a house, and then essentially call safe if they reach the driveway. And
Wasn't that what the trial court's central or core ruling here was? The trial court did a really good job here of covering all bases, I think, in its denial of the motion to suppress. But the trial court was particularly bothered that the defendant, with the officers blue lighted him up, the stop occurred 5 miles away for legal purposes. Although the trial court didn't state exactly the grounds supporting that finding, the trial court was absolutely, in my mind, troubled, bothered by this 5 mile, it wasn't reckless driving, but this 5 mile evasion from the officer. So I do agree with you, counsel, that is a powerful finding of the trial court here.
And you're absolutely right, Your Honor. That was the court's primary concern. It may not have cited State versus Talley and then said this is factor 7, but
General,
it did.
Can you use hot pursuit? Let's say this is a home. Can you use hot pursuit as a basis? You can use it to enter the home. Can you use it to search the home in an absence of a search warrant? So if I'm chasing somebody in and I apprehend them and they ran away from me as a police officer, don't I have to still go get a warrant to conduct a search of that home?
I do think potentially under the hot pursuit, it would depend on the crime for which the pursuit was engaged. If there was the potential for finding evidence of the crime for which the officer was pursuing the defendant, it could be different. And I will admit here.
Do you have any authority to support that proposition, that the nature of the crime would affect, once you've apprehended the fleeing suspect, that you could engage in a search of the home based upon the crime that's at issue? What would you point us to?
Off the top of my head, I don't have any authority, and that's not what the state's not arguing here that hot pursuit is what authorized the search here. I mean,
you're traveling under automobile exception, right, in terms of the basis of the search?
The automobile exception and the plain view doctrine. And just to be candid with this court, I know I can't remember them off the top of my head, but in researching this brief, I found cases that said the search incident to arrest only applies if there's likely to be evidence of the offense for which the defendant was arrested. I don't think that would apply here, and so that's why the state didn't argue it below, and we haven't advanced that in our brief. Our 3 arguments are that he doesn't have standing, and that even if he does, this was not curtilage, and that the search was proper under the plain view doctrine in the automobile.
So let me ask you about the curtilage here. The foundational, all the Dunn factors, the core thing Dunn's getting at is, the central question is whether the area in question is so intimately tied to the home itself that it should be placed under the home's umbrella. Why isn't I walk out down my driveway, I walk to my mailbox, why isn't that so intimately tied to the home itself that it should be regarded? Because everything in Dunn is just about answering that question. There are different ways of thinking about that question, and the U.S. Supreme Court and the Tennessee Supreme Court have repeatedly said we don't apply this mechanically. So why isn't that so intimately tied to the home?
I think I would actually point the court back to the Girl Scout test that's been alluded to in some of the questioning here, and it's whether a Girl Scout selling cookies would think this is the way to
But
get.
Council, my front door is still my curtilage. The Girl Scout can walk all the way up to the front door, and there's zero question that that's the curtilage of the home. So how does the Girl Scout get you away from curtilage?
I think for your mailbox hypothetical, if the Girl Scout, if there's the path to the front of the home, which absolutely, that the front of the home, the doorstep, not disputing that that would be curtilage, but if it's a path that would invite a passerby to reach the door of the home, that's not part of the curtilage. And what we have here is just an open driveway where there were no steps taken to conceal the area from people that were driving by. There was no attempt to make the area private. There weren't any no trespassing signs. This was the...
Have we said yet whether a driveway, has this court or the Tennessee Supreme Court said whether a driveway is part of the curtilage?
I don't believe that either this court or the Tennessee court has specifically held one way or the other. I think it's been a very fact-intensive inquiry. It's also one that neither this court nor the Tennessee Supreme Court has had too many opportunities to confront here. But when we apply the Gunn test, this just simply does not qualify as curtilage. There's plenty of steps that someone can take to sort of exclude people from that area of the home, and we don't have any.
And even the Tennessee Supreme Court and this court, there was a split decision, even with no trespassing signs put up, that was considered not a part of the curtilage. So it takes a lot to establish an expectation of privacy in a driveway, or at least it appears that way when you're looking at specific facts for this reason. So anyway, I apologize. Continue.
No, but you're absolutely right, Your Honor, and I'm glad you brought that up with State versus, I believe it's State versus Christensen with the no trespassing signs. It is very hard to have a reasonable, legitimate expectation of privacy in a driveway, and this case falls well short of anything resembling that. And it's actually helpful to sort of contrast this case with Collins versus Virginia, where in Collins, the motorcycle was enclosed behind, I believe it was 2 brick walls, and then the third side was the house itself. To get to that enclosed...
And it was covered. It was covered.
It was covered as well, and the officer had to walk past sort of the normal pathway that would have led to the front door to get there. We don't have anything like this here. The vehicle wasn't covered because it had been driven there 5 miles after the defendant was fleeing from police. There's not a fence. There's just no indication that the property owner intended to keep people out of this space. And because we don't have any evidence of that, this simply was not part of the curtilage of the home. Officers had a right to be there, and they had a right after they arrested the defendant to then approach the rogue and look inside, and then also relying on the plain smell of marijuana that the officer smelled when he arrested the defendant. All of that taken together was more than enough probable cause under the Plainview Doctrine and the automobile exception to justify the search here. And that's even if this court reaches the issue, if it finds that the defendant has standing. And if there are no further questions, we would ask this court to affirm. Thank you.
Thank you. Mr. Duggar, you have 4 minutes, sir.
Once again, we just wish to reiterate, we are not challenging the officer's entry onto the property. I believe Lieutenant McPherson's a fine officer and had a very valid reason for being on the property. We would just assert Mr. Gunn was not a casual visitor to the property, as mentioned in the state's brief with the Harris case. It's clear he's a regular visitor and at worst a casual overnight visitor due to his clothing being there, him driving the car back there, the officer's knowledge that he had prior resided there. These long-term connections from Ms. Anderson's testimony during the trial as well as Diamond Wilson's, I believe, help that argument. Ms. Jessica Anderson testified at the trial that Mr. Gunn had been staying with her off and on. That's on page 19 of my brief. Mr. Gunn, while he did state that he was homeless.
The officer didn't know know that information, right? I mean, the officer asks, where do you live? And he says, I'm homeless.
Yes,
And so, I mean, and we're supposed to be assessing this in connection with what officer reasonably knew at the time. And so if I hear the guy is homeless, I'm struggling to see how I'm supposed to know he's actually staying in this house. And what facts is he aware of? I mean, I understand
yes.
there's additional testimony that's going to come in later, and that he was staying there and there may be clothes there and all of that, but the officer at the moment making this determination, especially when considering light of reasonable factual errors, what's he supposed to know there at that moment that's going to tell him overnight guest to that place?
Unfortunately, this court is left with that being an unanswered question due to my inability to ask that question at the suppression hearing. It's not something I envisioned. So I believe the officer still testified that he knew Mr. Gunn had prior connections to that.
Based
I
on the
can assume,
aggravated burglary warrant.
and his prior dealings with Mr. Gunn. And so I think that based on that, I believe we could have done a better job of fleshing that out at the trial court level. However, it just wasn't done. It would be unfair for me to make assumptions or out-of-court conversations that the state is just not there for. So I can't go any further into that.
But doesn't that point to the lack of error by the trial court in terms of its determination that there wasn't a privacy protection of the home that extended here in this circumstance? And it's, the trial court, it seems to me the core of the trial court, or part of the important part, maybe not the core, but the important part of the trial court's finding was essentially the officer was entitled to believe him. I mean, he says I'm homeless, and the officer's entitled to believe him. And in many respects, maybe the defendant sunk his own case by telling the officer he was homeless instead of saying, I don't have my own place, but I stay here regularly.
Yes, and I believe the defendant helped to highlight that point as to why he said he was homeless, which was his belief that he did not live there because he was not on the lease.
But how does the officer know that's the answer he's getting? I mean, we're, again, reasonable mistake of fact here. And the officer, you're told you're homeless. I'm struggling to see how he's supposed to know he's staying in that duplex.
I believe the officer could have asked more questions, just like I could have asked more questions in the suppression hearing. So we're left with hindsight being 20/20, but unfortunately we just don't have the line of questioning. I believe where Mr. Gunn was staying at the moment was not central to Lieutenant McPherson's investigation, so Lieutenant McPherson didn't waste a lot of time asking Mr. Gunn exactly where are you staying. I don't believe Lieutenant McPherson believed this was curtilage at the time, so his line of questioning would not be such to really focus on where are you staying, David. It was more so, hey, we have to take you to jail for your warrant. So I want to thank you for your time, and I would just ask that you reverse and remand this case.
Thank you, counsel. The matter will be taken under advisement. We appreciate the parties' arguments and briefs. Please call the next case.
State of Tennessee versus William Joel